Back with us on the SportsMax zone, we are still awaiting word on whether Jamaica and West Indies opening batsman John Campbell will appeal his 4-year anti-doping ban. Campbell's legal team has until October 28 to file an appeal to the Court of Arbitration for Sport, the CAS, or CAS, as we say in the industry. The 29-year-old received a notification of the decision on Friday, October 7, from an independent anti-doping disciplinary panel that was in Kingston. The ban relates to a failure or refusal by Campbell to submit to a sample collection after proper notification. That refusal or failure is in breach of Article 2.3 of the anti-doping rules set down by the Jamaica Anti-Doping Commission. Campbell was represented at the proceedings by Ayana L. Thomas and Mark Paul Cowan of the firm Nunez, Schofield, De Leon and Company. That team says it's disappointed with the ruling. Now, as we try to get a better understanding of the factors which led to that ruling, for that we're being joined by Chairman of the Jamaica Anti-Doping Commission, JADCO, Alexander Williams. Welcome to the program, sir. Good to have you here.
Nice to be here. Nice to be here.
All right. Insofar as JADCO's case is concerned, Alexander Williams, what do you think the success of its case, what did it turn on? What was the key piece of evidence or key material submitted by JADCO that caused the panel to find in its favor?
Well, I don't know if it's so much the key bit of evidence presented by JADCO. I think looking at the decision, the decision really turned on the tribunal failing to accept the explanation given by the athlete in response to the allegations put forward by JADCO. He is trying to give what is called a compelling justification not to submit to the testing at the particular time, and it appears that the panel found it wanting, and so therefore they found that there was an ADRV and imposed a penalty.
Yeah, we've heard various things about what happened, but not from the horse's mouth, that the time of the test. The reason I framed the opening question like that was I wanted to know what it is that JADCO submitted in terms of what happened when its DCO went to take the sample from Mr. Campbell. Did they go at the time, communicated to him? Yeah.
Right. In a nutshell, it appeared that the JADCO, DCO, and personnel attended at his place of residence. It appears minutes before 6 a.m., which is, as it turns out, outside that window, so to speak, that I would have been provided under the whereabouts filings of the athlete. However, and this is the point that needs to be made, and made it so many times in the past, if you you make your whereabouts filings, an athlete says, I'm available between 6 a.m. and 10 p.m. or whatnot, right, at a particular location. If we turn up at the location within that time and you're not there, it is a missed test, right? If we turn up to test you outside of that period and you're not there, that's fine, because it's random testing and we take the chance of coming to test you outside of whereabouts filings. But if we turn up at that time and you are there, you are to submit to testing. You can't say, oh, it's not yet 6 o'clock or whatnot, and refuse on that basis. And if you're going to give another compelling reason, it has to be compelling. It has to be something that is credible in the first instance. So it appears as if what the athlete said, from what I understand from the evidence, was that it was twofold. He asked the DCO and the personnel, so what if I wasn't here? And the DCO responded to say, well, if you wasn't here, then that would be that. And then he says, well, then I'm not here. You get me, George?
Yes.
Which, come on, I mean, you can't just say I am not here and that's that. That can't be the case. The other thing is that I understand that he tried to convince the panel that he was, and I'm using, I think these are my words or his words, he was disoriented at a particular point in time. He might have been suffering from some maladies or whatnot and made him disoriented, and so he wasn't aware of himself and all of that. But his own evidence or evidence from persons called on his behalf sort of contradicted that statement that he was disoriented. So in the round, the panel came to its decision and therefore imposed
and for those people who don't know Alexander Williams, the sample that Jadco was seeking to take was a blood sample.
That is so.
Yeah. And so you say it was agreed in front of the panel that at the time he was expecting the DCO to turn up at the location, the DCO actually arrived there a little bit earlier than scheduled.
So it appears. I must tell you.
And you're saying that according to the rules, arriving a little bit earlier than advertised or agreed and expecting a sample, there's nothing wrong with that?
There's nothing wrong with that. As I said to you, the first position is that any NADO, any authority, testing authority, under the international standard for testing and investigations, can test an athlete at any time. That's the overarching thing. So there are times when Jadco or whoever will come to test an athlete within the period set out in the whereabouts filings. If the athlete isn't present, then that is in itself an ADRV. And would result in a missed test. So you must appreciate, and I take no joy in this case, quite frankly, because I thought that we were beyond this point, certainly with our local athletes, and especially an athlete at the international level. You cannot turn away DCOs and drug testing personnel in the way that it appeared he did.
Right. And Alexander, I want you now to talk to us about the length of the sanction, because he's been given a 4-year ban. He's 29 years of age, so of course when you work it out, by the time the ban expires, he probably would not be, fit and ready to play cricket. Talk to us about, how they determined the 4 years.
Well, I want to leave that to my the attorneys representing Jadco to interpret as to how they came to which I understand is the maximum in the circumstances of this case. So I don't want to get too much into it because, of course, the athlete may pursue this matter to cause, but I suspect they may have come to the conclusion that the athlete's actions were deliberate to avoid the testing, not negligent, and so therefore thought it best to impose the maximum period.
And how does just in terms of clarity how this works? Is it that your attorneys would have asked for 4 years, or given what is on paper, the panel, the tribunal the panel in ruling would have said, based on what's presented in front of us, we think that 4 years is fair for the infraction?
I'm not quite sure if in this instance the attorneys represented us asked for it, but whether or not our attorneys asked for it, the panel is entitled to, impose a particular sentence that they see fit.
Do you have previous form in your attorneys asking for a particular punishment, the duration of a punishment?
If there's previous...
Is there previous form? You say that in this instance you're not quite sure if your attorneys asked for the 4 years, or whether the panel moved to hand down the 4 years just by the letter of the law. But I'm saying, if previously Jadco managing cases, if there has been any occasion previously where the attorneys have asked for a particular sentence, given the guidelines in terms of the rules.
What I can tell you is this, that in previous times when we are able to, because again, with all of this, we are guided by WADA, right? There have been instances in the past where we have been able to, in accordance with WADA directives, ask for leniency.
Right, and that's where I was going, because as Mariah pointed out...
I don't know if the facts of this case fit that.
Yeah, okay, understood. The attorneys for him, they issued a statement, Alexander Williams, which you would have seen, and they said that, look, procedurally, they made some points that Jadco's attorneys did not contest, and they felt that on the strength of putting some points on the table regarding the procedures followed by the DCO, Doping Control Officer for those who are wondering, and related matters, that they felt that the fact that Jadco's attorneys did not contest these mitigating factors that they put down ought to have translated into a discount for Mr. Campbell. And I wanted to put that to you, why you think that was not applied in this case.
I don't know how accurate that statement is. As you can imagine, I wasn't present at the hearing. But if I'm to read, looking at the decision itself, right, the written decision, it does appear that the panel addressed its mind to whether or not proper procedure was followed on behalf of the DCO, and ultimately said that in substance, proper procedure was followed. And if I might put it another way, they're not getting into minutiae details as to whether, and I'm just talking out loud here, whether
yes.
the DCO showed his ID or not. But did he get an opportunity to show his ID when Mr. Campbell kept his door closed and was shouting from behind a closed door, you know? So, and the other thing is, I don't see from the written decision much of argument on mitigation or an argument as to deliberate conduct or what have you. Either way, I don't see that coming out from the decision that I read.
Right. We've just pulled up for you, just to provide clarity and to remind the viewers who've been following this story from yesterday, the statement from the attorneys representing John Campbell, who spoke about several breaches by JADCO of mandatory international standards for testing and investigations in respect of the notification of the athlete. The attorneys said, in their view, those were not adequately considered by the panel. And then here's this part, that there were several mitigator factors supported by evidence. So I don't know if this would qualify as minutiae. They said several mitigating factors supported by evidence which were not challenged by JADCO and which ought to have militated against the imposition of the maximum penalty. How I was looking at it, and I won't say interpret, of course, I leave interpretation to you. You're an attorney of 25 plus years. That's for you to speak that way. But how I looked at this, Alexander Williams, was them already laying out the case on which they will make their appeal if they so choose. And again, if they've said, and it's a reputable law firm, you know them very well, they've said, look, there were things supported by evidence that JADCO didn't contest, and that they're surprised about the length of the ban, given that they felt that the panel should have used these things to discount the penalty levied on Mr. Campbell.
I can't say much on that. Again, from my reading of the decision, I'm not quite sure what my learned friends were referring to as factors in mitigation. So I don't know if I can take it any further than that. I mean, I suppose they will have that opportunity to explore that at the Court of Arbitration in Sports. I
hope you can help me with this one, though. In terms of the exchange between John Campbell and the doping control officer, was it a respectful exchange? Was it an amicable exchange? Was there hostility from Mr. Campbell to the doping control officer?
I can't tell, again, if there was hostility. And I'm prepared to assume that there wasn't. There may have, if I might, and I really don't want to layer any characterization on the evidence that was before the court, because what you're talking about there, it's the kind of thing that would come out in the course of evidence, and you're looking at the demeanor of witnesses and so on. But what I did see was, there was a question from Mr. Campbell to say, if I wasn't here, how would that work out? And the DCO responded, well, if you wasn't here, then that would be that. And then he says, then I'm not here. So if I'm to go off those words alone, it does appear to be some amount of disrespect.
Yes.
Using those words alone. So I don't know. I don't know how else to answer your question, George.
I hear you, and I realize that the things you have to be balancing in your capacity. But you spoke about shouting through. What prompted the question was you said shouting through a door that was ajar rather than being open and talking to you with respect.
I can't say if it was locked, ajar, whatever. But it does appear as if there was no immediate engagement between the officers and Mr. Campbell.
Yeah. Based on your experience, Alexander Williams, do you expect that Mr. Campbell's attorneys will be filing that appeal?
Wow, based on my experience. Well, putting myself in the shoes of the attorneys, I would weigh up the chance of success and what is at stake and take the decision accordingly. I suppose the main consideration is what do you have to lose? So, having said that, I suspect there will be an appeal.
There you go. All right, thank you for your time this afternoon. I want to wish you and the team at JADCO all the best, and we wait to see the next move because the ball certainly is in the court of the Campbell legal team. Thank you very much for your time.
Thank you, sir.
Alexander Williams there, the chairman of JADCO. He previously served, well, this is his second stint as JADCO chairman. And yeah, the ruling handed down by the independent disciplinary panel. And they've said that John Campbell is guilty of refusing to submit to a sample and 4-year ban. We wait to see if he will appeal. We are 7 days away. Yes, sir, 7 days away. Devin Booker and company. 7 days away from the start of the America's Netball World Cup qualifiers at the National Indoor Sports Center. We're 5 days away from that, but we're 7 days away from the start of the NBA. Yes, I'm not mixing my metaphors. I'm getting them right. 7 days away from the start of the NBA, but 5 days away from the start of the America's World Cup qualifiers where netball is concerned. So we're talking basketball, we're talking netball. Basketball, the NBA is in the US, but the America's Netball qualifiers are in Jamaica at the National Indoor Sports Center, and we're not too far away from that.